Kyaddaaki Martha Nkwanza Katanga muwala w'omugenzi Henry Katanga alabiseeko ku kkooti y'eddaala erisookerwako ey'e Nakawa okuvunaanibwa emisango egyamuyisa mu kkooti eno gye buvuddeko. Mu kkooti ng'agasimbaganye n'omulamuzi Elias Kakooza, Martha Nkwanza Katanga agguddwako omusango gumu ogw'okwonoona obujulizi obwali bugenda okukozesebwa mu musango gw'okutta kitaawe Henry Katanga.
Nkwanza Martha, you're charged with one count, which is destroying evidence contrary to section 102 of the Penal Code Act, Cap 120. It is alleged that you, Nkwanzi Martha Katanga and Kankwanza Patricia, on the 2nd day of November 2023 at Imbuya, Chwatu Road, Nakawa Division in Kampala Capital City, knowing that device things at the scene of crime may be required in evidence in judicial proceedings, removed or destroyed them or rendered them illegible or incapable of identification with intent, thereby to prevent them from being used in evidence.
Oluvannyuma lw'okuggulwako omusango guno, oludda oluwaabi wabula luwakanyizza ekyonookubaako kyanyaga ku misango egimugguddwako bwe lutegeezezza nti kkooti eno terina buyinza kuwuliriza misango gimugguddwako. Akageri kekiri nti gya nnaggomola era nga fayiro y'omusango guno ekwatagana ne ku nsonga z'okutta omuntu nga mu kiseera kino eri mu kkooti enkulu okwekenneenyezebwa.
Shall cover the details of that in this rejoinder, Your Honor. It is true we prayed for warrant of arrest because this court has jurisdiction to issue warrant of arrest because the appearance of all charged before it in all cases, capital or non-capital, because it is the charging court of first instance. Yes, we note the provisions of section 161 of the MCA, but Your Honor, that section does not address the question of several accused persons appearing on the same charge sheet with a mixture of capital and non-capital counts. Your Honor, we have had the privilege of being guided by the jurisprudence that apply to this scenario. First, the authority in the Human Rights, the Foundation for Human Rights Initiative and Attorney General cited is distinguishable from the present facts because, yes, it's distinguishable from the present facts because that case dealt with situations where magistrates' courts decline to grant or entertain applications for bail where they have clear jurisdiction. In our scenario, there is no explicit legal provision in the MCA that empowers a magistrate's court to entertain a plea in one count on a charge sheet bearing a capital count. And Your Honor, as you can realize, the case that you are dealing with, even in your register, the court's register, it appears in the capital offences register, and it was registered as such. The number accorded to the matter before you is capital.
I'm sorry, Your Honor, but I would have expected my learned friend to join on my submission. I never made any submission regarding the register, so I pray that you expand that from the record.
I have been tasked to explain. I have also been challenged that I have not cited the law, and I'm just giving a preamble to the law that I'm about to cite. But if my land brother is not comfortable, I can still refrain from that and make the point that, which I have already made, that there is no specific section within the MCA. That means that because you are dealing with a capital charge sheet, which is registered as such, and that charge sheet also has non-capital offenses, and in the absence of an explicit provision, there is doubt as to whether this court has the jurisdiction. So where there is doubt, we are guided by section 39 of the MCA. Your Honor, section 39, I shall read it for avoidance of doubt. It provides in subsection 1 that whenever any doubt arises as to the court by which the offense should be tried, I underline trying because plea taking is an act of trial. So wherever there is doubt, whenever doubt arises as to the court by which any offense should be tried, any court entertaining that doubt may, in its discretion, report the circumstances to the High Court, and the High Court shall decide by which court the offense shall be tried. Otherwise exist was already resolved by the High Court in the case of Uganda versus Ndiamohaki, Julius, and others. It's a criminal revision number 1 of 2016. In this case, the decision, Your Honor, which should be on page 5. Do we have another copy? Page 5. Let me try to get another copy for my land brothers. We should be having it somewhere. I can use this. This one, this one has our kasasi. Where is it? So, Your Honor, on page 5, the guidance of the High Court is that where a charge sheet bears both a capital and a non-capital offense. The gravest offense in a multiple count charge sheet determines the jurisdiction. I want to be sure, Your Worship, that we are on the same page. So in simple terms, where you have more counts, then if you want to be guided as to where jurisdiction falls, you look out for the gravest offense. And if the jurisdiction of the gravest offense is not vested with the court, then the court has no jurisdiction. Your Honor, this court will also take note that whereas plea was taken for the other two accused persons, that exercise is subject to a revision process. In criminal revision case number 1 of 2024, and the gist of that revision application is to correct the exercise of plea taking. Now, given that that is still pending before the High Court, and in view of the clear authority of the High Court on the matter, as we have cited, it is only right, proper, and prudent that we await the guidance of the High Court before we can determine whether or not.
Your Worship, sorry, I don't want to interject. But
if the issue of the revision is a question of judicial notice to this court. So this court is already aware, the matter is before it, and the file was actually called and sent by this court. This court is even aware that it is pending. Yes.
See, I'm sorry about that, but my land friend is making one revision. When he's kind of emptying his own application in the High Court.
No. Yes. Yes. No, actually, Your Honor, I wouldn't have gone into that, except that it's a response to my land brother's submission that this court had already taken plea. You know? So because they said this court had already taken plea, so it should be bound, I am just explaining that that plea, yes, was taken, but it is a subject to a court process that is pending. So I believe that my reference to the revision application is well premised as an appropriate answer to the submissions from my land brothers. Anyway, the conclusion, Your Honor, is that in view of all this, the right thing to do is to simply communicate the charges, remand, and we await for guidance on this rather contested matter. Otherwise, if this court went ahead to take plea, then we will be disregarding even the contest, the revision application that is pending. We so pray.
Magdusman Kabega munnamateeka wa Nkwanza awakanyizza okusaba kw'oludda oluwaabi bw'ategeezezza nga kkooti eno bw'erina obuyinza okukkiriza ono okwanukula ku musango ogwo mugguddwako nga bwe kyakola ku bavunaana abalala bavunaanibwa ku musango gwe gumu.
First, that the state did apply the 8th that suspect should be arrested to appear in court to take plea and pray for warrant of arrest. Now, that being the case, the suspect, much as the warrant issued but not signed by the court, she opted to appear to answer the charge in motion. The offense for which the court has read to her prescribes a sentence not life, not death. It is 3 years. And they are on section 161 of the Magistrates Act. One day, it says, subject to this section, Magistrates Court presided over by the chief, which you are aware of worship. Subsection A says, chief magistrate may try any offense other than an offense respectful to the maximum penalty, death. The charge that has been read to her does not attract that sentence. Provides for it. Therefore, she must take police abortion for the offense which has been read to her. Your Honor, the fact that she's on a charge sheet where first suspect is charged with murder has not in any way enclosed this court jurisdiction to run away from trying this offense. Honor, there is also authority to say that where the magistrate's court laws with permission to try an offense, also laws with permission to pass a sentence, must proceed to try that offense. Pass the necessary sentence in accordance with Your Honor, like friend, or maybe the authority that we have got to you is the Foundation for Human Rights Initiative versus the petition number. Constitutional petition, Your Worship, number 3. Constitutional appeal 3209. Fire Supreme Court. Your Honor, the prosecution is trying to appeal the court to trade the fact that because they have put the charge of account of murder, that therefore you cannot ask the suspect to take plea. The land friend has not provided you any provisions of the law. So therefore, you can only go ahead to ask the suspect the charge as friend. Your Honor, you also realize that the other suspects who are on remand did take plea before you. My line friends were in court. They are the ones who framed the charge, and they did not complain like they are now complaining. Cannot be allowed to eat it and they can have it. So the Honor will pray.
Mr. Jonathan,
wano kkooti oluvannyuma lw'okuwummulamu eddakiika 35 omulamuzi Elias Kakoza mu kukomawo agobye okusaba kw'oludda oluwaabi bw'atyo n'akkiriza Martha Nkwanza Katanga okwanukula ku musango ogumugguddwako.
counsel for the defense and the prosecution as to whether this court has jurisdiction to take plea in the count 2 of destroying evidence, contrary to section 102, which carries a maximum sentence of 7 years imprisonment. The state has raised objections to the effect that this court has no jurisdiction to take a plea on a charge sheet with the count of murder. The defense counsel vehemently refuted the above assertion for reason that the charge before which the charge that A3 is charged with is triable by this court, notwithstanding the fact that it appears on the same charge sheet with murder. Now, for consistency, I will hold that this court has jurisdiction to take plea. On 21st of November 2023, accused number 2, accused number 4, and accused number 5 appeared before this court, and I proceeded to take plea, which was not contested by the prosecution. State has talked of some division, but you don't have yet a decision in this court stopping me from taking plea. For those reasons above, I overrule the objection, and this court to proceed and take plea. Let the charge be read to the accused person.
Nkwanzi Martha Katanga, you're charged with destroying evidence contrary to section 102 of the Penal Code Act, Cap 120. That you, Nkwanza Martha Katanga, and Kankwanza Patricia, on the 2nd day of November 2023 at Embuya Chwatu Road, Nakawa Division, Kampala City, Kampala Capital City, knowing that device things of this at the scene of crime may be required in evidence in a judicial proceeding, you removed or destroyed them or rendered them illegible, incapable of identification with intent, thereby to prevent them from being used in evidence.
True or not true?
Wadde nga bannamateeka badde basabye kkooti okutankwanza awatali kusaba kutebwa kakalu ka kkooti, wabula omulamuzi Elias Kakoza akalambidde.
Very brief to rejoin Your Honor. Your Honor, my learned friend has said that this is an application for release, and that the court should be consistent in enforcing detention. Your Honor, of course, the court cannot, each accused person must be looked at on their own. A3 is a new mother of a 1-month-old baby.
Just a minute, Your Honor.
When I forgive my page, see that of space the back.
Yeah, it's
I mean, it does not.
It's okay. With due respect, what my land good brother Harrison is doing is to sort of give a rejoinder. And I have not made a reply. My submission and the approach that I have taken is not to first reply to what you have done or want to do. I am seeking the guidance of court on how we should proceed in the manner I have submitted. I have not gone through the merits of the replies yet.
The court towards the angle of consistent detention, and I was just also.
I thought your video was not like him seeking consistence of court.
That is exactly what I'm addressing. And I am saying that each person must be looked at. He has made a number of, he has said more than that. He has talked about his revision application as though it were a stay of proceedings in this court. He has talked about, and yet it is not. It is also not served actually at the moment. So in the guidance that he seeks, I think the court needs to be clear that it is not a stay. Secondly, it is not served. Fundamentally though, yes, fundamentally the last point on section 65 is that in section 65 the court is simply exercising a discretionary power. Which discretionary power? We're asking that the court listens to an application on the basis of liberty, presumption of innocence, and compassion. Worship is the High Court already, since my land friend is talking about letters of revision, there's also another letter from the High Court on hearing of bail on this matter by the Deputy Head of the Criminal Division.
Yeah, directing this court to hear the application.
Yes.
Okay.
Or 75 or 77. The correct description of such an application is an application for release by whichever approach. This court has already properly guided itself of the need for consistent practice. It is the same reason, Your Worship, that notwithstanding the objections on jurisdiction, you were pleased to take plea for the sake of consistency. I want to remind this Honorable Court that prayers for release were attempted in respect of A2, A4 and A5. And this Honorable Court guided that in the face of the existing application challenging jurisdiction and is still pending determination by the High Court, it would not be proper to entertain the application for release. So before I even attempt to make a detailed and formed replies to either the application for under 65 or the presentation of sureties, I'm seeking this court's guidance as to whether consistency would not require that we maintain the status quo. And I am highlighting the word consistency as guided by court. Your Honor, once I'm properly guided on this, then I will have the pleasure to submit further.
This court is enforcing detention, as you are putting it. This matter was coming for bail application on 8th last Monday, but I could not entertain the application, bail application. As I was told of the application in High Court, and there was a data calling for the file. This court feels like it's put by state that we need to be consistent in this matter. I have appreciated your submission about the state of the accused person, accused number 3. I'm told that the application High Court is fixed for 16th of this month. You could apply for bail in High Court, which is under the division. Otherwise, like it's put by state, I can't proceed to entertain a bail application in this matter this time. I therefore remand the accused person to 22nd of this month, date which we had fixed earlier.
Kooti etaddewo olwanga 22 omwezi ogwa January omwaka gwa 2024 okugenda maaso n'omusango guno, era nga wano Martha Nkwanza Katanga nakawere w'omwezi ogumu asindikiddwa ku alimanda e Luzira.
Mulese natekinga kuli kooti ya mulemanda era kyabadde kiri expected nakikimanyi.
Ku nsonga ya bail muzenga musaba lero musabidde ne bali eri mugenda kikola
bondi release on bond. Ngeteeka bwe ligamba naye agamba nti engeri gye wali application High Court ogimalire mu High Court.
Wadde ng'enfunda eziwerako kooti y'emu ezeeyisa ekiragiro eri Mole Katanga mukyala w'omugenzi Henry Katanga okulabikako mu kooti, wabula ne gye buyino takubwangako kya mu lubaale. Omusuubuzi Henry Katanga yattibwanga ennaku z'omwezi 2 omwezi ogw'Ekkumi mu mwaka gwa 2023 mu maka g'Embuya Chwatu Road mu ggombolola y'e Nakawa mu disitulikiti ya Kampala.